Welcome back to Good Law, Bad Law. In June of this year, the National Rifle Association filed for, of all things, bankruptcy in a federal court in Texas, brazenly acknowledging that the reason they were filing for protection under federal bankruptcy law was to escape the New York Attorney General, Letitia James, who is bringing legal action against the NRA for its widely publicized and well-documented, I'll still say alleged fraud, corruption, and mismanagement. This is a pretty extraordinary use of the bankruptcy protection. And so we invited Bruce Markell, who is a former bankruptcy judge from Nevada and a very experienced lawyer and now professor of law at Northwestern University's law school in the area of bankruptcy. He's written extensively on bankruptcy, and we're talking about whether the filing of bankruptcy seeking to run from any accountability that the New York Attorney General is pursuing is appropriate, is valid, can stand, may be bad faith, and may find the NRA in even more trouble than it's in right now. So this is not your typical bankruptcy story. This is one involving perhaps the most controversial nonprofit advocacy group in the United States, and for many years in that role. So my guest, Bruce Markell, really great conversation. He's fantastic. I know you're going to enjoy this episode and learn a lot, as I have. Please, everybody, stay safe. Continue to hold tight until everybody can get vaccinated and we can finally put the worst of this pandemic behind us. Please wear masks, socially distance, and all that stuff so that we can stay responsible and safe for ourselves and for our families and friends. Everybody stay tuned for this episode of Good Law, Bad Law. I want to welcome my guest on today's episode, Bruce Markell. Judge Markell, thank you so much for being on Good Law, Bad Law to talk about the NRA and bankruptcy.
Thank you. And it's just Bruce. It's fine.
Okay. Well, I'm a lawyer, so I'm used to when I'm in front of any judge, current or former, I'm used to the formality, but thank you, Bruce. And just by way of background, for people to know, Bruce, you teach bankruptcy law at Northwestern University, Pritzker School of Law. I say Judge Markell because you were a United States bankruptcy judge for the District of Nevada for 10 years until about 6-7 years ago. You've practiced law in the area of bankruptcy. You've taught at a variety of law schools. And early on in your career, clerked for the Honorable Anthony Kennedy when he was still on the Court of Appeals in California before he was elevated to the Supreme Court. So
I'm
really,
old.
So well, I wouldn't say that, but I would say a distinguished career in bankruptcy, and perfect for our subject today. Really an extraordinary bankruptcy story. Probably not many people think much about bankruptcy being extraordinary, but if there is a case that is indeed is extraordinary and raises all kinds of questions today, it's the bankruptcy of the National Rifle Association, the NRA. So, I did some looking around, but perhaps you could give us and our listeners the basic predicate for the NRA's seeking protection under federal bankruptcy law, and then we can get into some of the ways in which this, as I suggest, is extraordinary, and we'll see what to make of that.
Well, to say what the predicate is to try and get inside the NRA's head. And unfortunately, I think they're kind of schizophrenic on this. I mean, one of the extraordinary things about it is it's not exactly as though the NRA as one agreed to file bankruptcy. I mean, it was delegated to a committee that probably did something that the people who delegated it to didn't think they were going to do. I mean, um, it's problematic. And anything I have no connection to anybody connected with the case. So everything I say is conjecture, but as a professor, I'm used to that.
Right.
I mean, in essence, what I think that they are trying to do, or at least what they have said that they are trying to do, is they're a long-term nonprofit organization that is organized under the laws of the state of New York. From time immemorial, the state has regulated nonprofits and charities and the like, and that's what the New York Attorney General has been doing. And the New York Attorney General, for whatever reason, believes that there was, and perhaps continues to be, fraud and mismanagement at the NRA in terms of expenses made and the like, and had started proceedings to basically terminate the NRA's existence. As charities go, that's relatively unusual, although it's not unheard of. I mean, this is the state. The state regulating nonprofits is what the state does.
Well, and it happened to the Trump organizations.
Yeah, there are all sorts of things. I mean, for example, false charities that solicit money fraudulently is the typical kind of ambit of this. So, what the NRA did was to say, and I think their exact words, "We're dumping you." And I mean, that was their press release. And they engineered a series of moves that enabled them to file bankruptcy in Texas. And through that series of moves, they have indicated a couple things. One, they wish to be rid of New York in, they believe, political harassment. Incorporate a new nonprofit in a much more friendlier atmosphere in Texas. And thereby avoid the scrutiny of the New York Attorney General by simply saying, we're no longer within your jurisdiction, we're moving to Texas.
Right.
Now, the way in which they did that is, as you say, extraordinary, because at the same time, Wayne LaPierre said he was dumping New York. They also said, we've never been stronger financially.
Right. Well, that is what seems like the most, from a bankruptcy point of view, even from a lay person's understanding of what bankruptcy protections are all about, seems to be the essential contradiction in the entire story here. They actually said on the day they filed for Chapter 11 protection that the NRA was on solid financial footing, and that they were in their strongest financial position perhaps than they'd ever enjoyed, and yet they're filing for bankruptcy.
Well, a couple distinctions only law professors would like. A lot of times people file bankruptcy not because they have fewer assets and liabilities, because they have liabilities that are due now and they can't monetize their assets. For example, in the early 90s, Texaco filed bankruptcy because a $9 billion judgment was levied against it for tortious interference with contract. Texaco filed, but even with a $9 billion judgment, it was solvent. It had more assets than it had liabilities. But like most people, it can't come up with $9 billion immediately to pay the judgment. And so, in terms of a cash flow problem, that was significant. And no one really kind of blinked an eye when they filed. I mean, America is somewhat unique among, although the tide is changing overseas, somewhat unique in nations in allowing non-insolvent companies to file. But usually there has to be some sort of financial concern. A lot of what so-called mass tort cases. I've been involved, for example, in the Pacific Gas and Electric case out in California. Pacific Gas and Electric filed saying they had $71 billion in assets and $50 billion in liabilities. It just so happened that 20 to 30 billion of those were tort claimants. And so they filed and said, we have no idea where this could go, but we need a process under which we can effectively manage these types of claims. And bankruptcy was the way in which to do it. And so it's not unusual to have a non-insolvent company file, but it is unusual to someone say we're in the strongest financial position we've ever had. I mean, I don't know. It could be that someone like the NRA could be the subject of a lot of class action lawsuits because of their positions on guns and various tort liabilities attaching to them. But that they certainly didn't point to that when they filed. All of their ire has been focused on the New York Attorney General.
Well, and to add a couple of examples consistent or contemporaneous with the PG&E case that you mentioned, but more recent than Texaco, Purdue Pharma is another example, one of the big opioid manufacturers that is looking at multi-billion-dollar settlements in mass opioid litigation, and the Boy Scouts of America to
take all the Catholic dioceses that filed because of the abuse. I mean, those are cases in which, again, people in the bankruptcy side of things call those mass tort cases. Those are cases in which A, the liability is both large and unknown, and B, the liability can be characterized, if you will, in terms of dollars. I mean, there's always a certain amount of moral blame to go around. But bankruptcy doesn't deal necessarily with moral blame. It deals with dollars and cents. And it has a system. I often say, for example, bankruptcy is like a class action by the debtor against all its creditors. It gets everybody in one forum. And once you can get everybody in one forum, you can talk about, well, what do we need to kind of work this out? Because often, although not always, often in a regular for-profit business, there's more value in keeping the assets together than breaking them up. And the question is, how do you squeeze the most value out so that people can get the highest return if in fact you've got somebody who's insolvent? A lot of that gets turned on its head when you have a nonprofit because its goals, its aims are much different than a for-profit company, which is again one of the reasons why the attorney generals in most states have jurisdiction and authority to review nonprofits as opposed to profits, because there's just not that kind of outside limiter or governor on it.
Well, but even adding the examples from these other cases, at least the Boy Scouts and the Catholic Church are technically nonprofits, but whether a for-profit company I mean, there are a lot of questions, some would say, as to whether they should enjoy a tax exemption or not. But that's another conversation, another topic. But they are technically nonprofits. Obviously, Purdue Pharma is not. PG&E is a regulated utility, but still for profit. But in each of those examples of large organizations that have turned to the courts for bankruptcy protection against these future large liabilities. I don't think that those organizations were at least so open about claiming politics, political motivation as the reason for it, quite in the same way, I'd say brazenly, that the NRA is saying that's why we're doing this, to escape essentially, a politically motivated witch hunt against the NRA.
I mean, I can't disagree with that. I mean, there are cases. There's a case out of your circuit, the Third Circuit, called SGL Carbon in 1999. That was very similar. And SGL Carbon was an international, if I remember the facts right, was an international conglomerate of carbon fiber producers who got hit, I think, at the time with the largest antitrust judgment in the U.S. And it was, I believe it was a German or some foreign holding company filed for its American subsidiary that was subject to this judgment, and filed press releases saying, we're fine, we can pay all our debts. We just want to take advantage of the bankruptcy system, A, to stop all the lawsuits against us, and B, to use the distribution. We don't think regular litigation is the way to go. And the Third Circuit had absolutely no trouble in saying that is not a good reason to file bankruptcy. Sorry, that's bad faith. Because it is bad faith, you may not use the bankruptcy system. And so dismiss the case. And I think there's 2 or 3 motions pending in Texas to dismiss the case. They all cite SGL Carbon.
Mhm.
And that's, we're going to have to take a look at that, because unfortunately, the statute, or fortunately, depending on your view, the statute that governs dismissal does not specify a lack of good faith as a grounds for dismissal. Everyone acknowledges that that's a permissible ground, but what good faith is, it depends on the vessel you're pouring the good faith into as to what shape it ultimately takes.
So we know how New York has viewed this bankruptcy in 2 different ways. The New York Attorney General, Letitia James, has filed a petition to have the bankruptcy dismissed in Texas, but also the action that the New York Attorney General has brought against the NRA in New York, I guess seeking its dissolution because of the fraud, the graft. There are all kinds of allegations of lavish pay to the longtime NRA CEO Wayne LaPierre, private plane trips.
Executive vice president, excuse me. He's the executive vice president.
He's the executive.
He's not the CEO anymore.
He stepped down as CEO. Okay. And that case is proceeding. The Attorney General's case against the NRA is proceeding in New York State Court. Oftentimes, when there is a bankruptcy, that serves to stay other litigation until the bankruptcy issues can be resolved. But in this case, the judge overseeing that case in the New York State Trial Court, I believe it was last week, recently ordered that case in New York should proceed, notwithstanding the bankruptcy. Does that, how do you view that tension here, given the way things are usually handled when there is a pending bankruptcy?
Well, going to be a long answer, so kind of settle back. When you file bankruptcy, one of the, if you will, an American innovation is that you normally get what's called an automatic stay, which is an injunction against any act to collect any debt or any action against the debtor. It's automatic because it acts without notice. It acts just upon filing. There's no court hearing. Indeed, many filing windows, if that's not a thing of the past anymore, but at least filing systems, will note on the bankruptcy petition itself the time filed down to the second. Because a lot of times people will file to try and beat a foreclosure or something like that. And so that's a central component of the bankruptcy system, under the notion that, listen, if someone files bankruptcy, they're being hounded, usually by legitimate creditors, but you get a better overall result if everyone kind of stops their bickering, talks about what they can do. Now, there are exceptions to the automatic stay. There are all sorts of exceptions. There are, the statute lists 23 of them. One of the exceptions is the exercise of the police power by the state. For example, one obvious example, one not so obvious example. The obvious example is someone who's on trial for murder can't file bankruptcy and tell the state, you can't try me. So there's an exception for that, obviously. But less obviously, say a restaurant files and it tells the health inspector, you can't inspect me. That doesn't fly. Someone is subject to regulation, is an exception to the stay. And so I have not seen what the New York court has done, but it doesn't surprise me, because I think the actions of the New York Attorney General are actions pursuant to the state's police power. It's what they have to kind of regulate as you go on. Just because you file bankruptcy doesn't mean you get a free pass on every form of regulation. It simply means that creditor claims, the types of things that bankruptcy focuses on, are stayed, but you're still subject to, work hour limits for wages and everything that the state regulates. And their concern actually is not so much with the law that's on the books, but the way it's being enforced. And again, the decision would be, the law on the books is that this is police power. This is the state. This is not an unusual form of state regulation. It goes forward. I mean, this happens. This comes up a lot, for example, when polluters file. If a polluter files, the state regulation of pollution keeps going and is in control. The liability for past pollution may be stayed, but ongoing acts, those aren't subject to the stay.
Well, that makes sense from how you explained why the what is the underlying reason for an automatic stay upon the filing for bankruptcy. It's to stop creditors
Right.
from proceeding with whatever actions they may be, litigation or other means to collect on debts. Here, and again, unlike these other examples that we talked about earlier, where companies or organizations were facing, even if the amounts of the liability were to be determined somewhere in the future, they were facing a known wave of litigation that was going to create clear and overwhelming liabilities in the future.
It would be like a Catholic diocese would not be able to stop a criminal investigation of the past acts of its priests.
Right.
But people who wanted to sue for those past acts would be stayed.
Right. But in here, and again, I think it seems extraordinary as in different than most other examples we can think of.
Right.
There is the criminal investigation and the criminal prosecution by the state attorney general, but there's the absence of any wave of litigation that could create future liabilities or just around the corner liability.
Yeah, I mean,
there happen, but we don't have right now that situation.
Or at least I don't think so. I mean, one of the things about bankruptcy is that it attempts to put forward a transparent process. I have not looked at what the NRA has filed, but my kind of sensibilities are that there are probably a number of pending lawsuits against the NRA for co-liability with respect to guns. I mean, if people will sue the manufacturer of guns for deaths or injuries, I'm sure the NRA is probably a defendant in there somewhere.
Mm-hmm.
But the fact that they haven't put those issues forward make me wonder as to whether, in the overall scheme of things, that's a big deal. I mean, I think they have said, and correct me if I'm wrong, that they're kind of net $50 million ahead of their liabilities.
Yeah, I made note of it there. At the time of the filing, their assets were reported at $203 million, which is a testament to the reach of the NRA with approximately 5 million members in the United States. 203 million in assets and 153 million in liabilities.
Right. So about 50 million net. So I would want to know the makeup of those liabilities. I mean, if they're kind of ordinary course, we're buying paper for our printer, it's one thing. If they're tort liabilities for the death of someone misusing a gun, or if the NRA said this is gun safety and it turned out not to be gun safety and they're being sued for that, that would be something different. I just don't know. But at the same time, their own statements are, we can handle all this. This is not a problem. Our problem is, seeking the New York Attorney General seeking to dissolve us. That's not, as you have said, that is extraordinary. That is not typically the reason one files for bankruptcy protection.
Well, and obviously you're not the judge overseeing this particular bankruptcy, we know, but as a former bankruptcy judge and as an expert in this field, what do you think are some of the considerations that a federal bankruptcy judge brings to the analysis, given the tensions, given what the NRA stated motivations are here? I mean, is it a legitimate basis for reorganization under the bankruptcy law that you simply want to relocate in a more favorable political / legal climate, move from New York to Texas?
There's a lot of questions wound up in that. I mean, let me start by saying, I would question seriously the decision to file bankruptcy and the way in which they did it. I think, as I'll explain, I think the NRA may have a malpractice action against its attorneys, but put that aside for a second.
I want to follow up on that when we get.
Yeah, as I say, just put it aside for a second. But let me kind of tell you kind of what I'm thinking here.
Yeah.
So in the typical non-political way, it is not unusual for someone who is in financial difficulty to for example, file bankruptcy and say part of our plan is that we are going to dissolve and reincorporate, say, in Delaware or some state that has more favorable corporate laws for us. That's not uncommon.
Right.
I mean, although just to throw in a fast fact, Chapter 11 filings are less than 1% of total bankruptcy filings every year. I mean, last year there were only about 8,000 Chapter 11 cases filed in the entire United States. So, and actually most of those had less than $5 million in assets. I mean, Chapter 11 gets dominated by, the 200 or so public company cases that get filed. And so when I say it's not uncommon, I'm kind of referring to that small slice. So first and foremost, it's not, the move to file bankruptcy if you're in financial difficulty, to restructure your capital structure in terms of even where you're organized, not unusual. But
and just for people who may not know, so when you say most cases are not Chapter 11, meaning most cases are not reorganization cases, they are
they're
pure
consumers.
Insolvency cases.
They're 99%, and I'm not just making it up. 99% of all cases are consumers, people like you and me, who can't make their mortgage, who are facing eviction. I mean, from the you said I was on the bench for 10 years. It was actually 9 years in one day, if anyone counts. But the vast mass of what you see every day are individuals who have personal problems. And that was the best thing about the job, was to be able to help people get back on their feet financially. And we have something. I mean, last year filings were way down because of the moratoriums on evictions and the like. But even last year, there was something like 550,000 cases filed totally. That's down. The year before was about 750,000. I mean, there are a lot of people who are. I mean, the stats are that most people don't have $400 in terms of a safety fund in case things go wrong. I mean, people are really on the edge of financial problems. That's not the NRA. Here's back to the NRA. I mean, I just want to say that the NRA is kind of dealing in an area not only that is unusual for them because there's relatively few political aspects, but also in terms of the financial difficulties. We're not talking about mammoth amount of cases that you might think from the number of filings. But other things that would concern me about the NRA were I a judge, as you said, one, the way in which they filed. One might say, how the heck did they get to Texas? What they did is they created in November of 2020 a wholly owned subsidiary called Seegert in Texas. And Seegert had absolutely, as far as I can figure out, absolutely no business purpose. But the bankruptcy laws allow you to file wherever an affiliate has filed. So when it came to January, although the NRA has absolutely no connections to Texas that would justify independently venue in Texas, they filed for Seegert, their subsidiary, and then they filed for the NRA saying, oh, an affiliate of ours, a wholly owned subsidiary, is in bankruptcy, so we want to be in bankruptcy with them. This kind of venue stuff is known and is, I would say, a known evil. Others would say not, primarily because of corporate reorganizations all occur in either New York or Delaware because of that affiliate rule. So, but first and foremost, to file for non-business reasons, a subsidiary simply to get venue, that alone is bad faith. And that bad faith would even if they didn't make these statements about their financial condition, would be a sufficient grounds, I think, if a given other, not knowing other facts, would be a sufficient ground to dismiss the case. Then you've got the bad faith issues in terms of, we're only doing this for a political reason and not for a financial reason. That gets back to my earlier discussion with respect to SGL Carbon. And so the whole filing to make an overblown statement is just rotten. It's rotten from the beginning in terms of how they manufacture venue. It's rotten from the fact that there's no real financial concern, or at least from what, I mean, it may turn out there may be financial concern, I don't know, but at least from their statements, they have no financial concern. And they're just trying to run away from New York. In addition, as you kind of pointed out, the bankruptcy didn't do jack about the action in New York because it's pursuant to the police power. So they got no relief from that.
Right.
Second, when they get into bankruptcy, they are going to, I mean, it's like living in a fishbowl. Everyone looks at you. And it's and this is a component, because I looked at the New York's motion to dismiss. There's also the longtime ad agency has also got a motion to dismiss. They are asking, in addition to dismiss, they say, well, listen, court, if you don't want to dismiss the case, appoint a trustee. And because here's all the evidence the New York Attorney General's found about fraud and misuse. That's a classic basis for saying, okay, the business can go on, or the debtor can go on doing it. We just think that its management is not the best to run it. We need kind of a bona fide management. And so they've exposed themselves to having their entire ability to control the organization dispossessed by a neutral trustee coming in and running the business. Thirdly, under the bankruptcy code, if a debtor has more than $5 million in debts, it's almost automatic to appoint an examiner. So even if you don't appoint a trustee, you can appoint a third party to come in and review the books and do in bankruptcy exactly what the Attorney General in New York is doing for the dissolution. And so for all those reasons, I mean, I have, when I've read stories about this, the metaphors are, I'm shaking my head, I'm scratching my head. No bankruptcy expert, I think, can figure out exactly why they did it this way. I mean, I think their headquarters are in Virginia. I mean, they could have filed in Virginia,
Right.
and avoided, a lot of these problems, except for the trustee and kind of the examiner issues. So I'm also one scratching my head and probably getting splinters. But I mean, this is, I don't, it's like I had a partner when I was a young associate who was a marvelous mentor. But if you screwed up, you had to go into his office, and his famous words were, "What were you thinking?" And that would be what I would be saying right now to the people who signed the petition. What were you thinking? What did you think was going to happen here?
Well, those words ring in my own ears from my father growing up, but that's again another story. But I want people to understand, before we get to the malpractice question, which I'm intrigued by. I want people to understand, because you've explained some reasons or some bases why the bankruptcy filing in Texas could ultimately end up being dismissed or tossed out of court. But what if it isn't? In other words, what is it that the NRA is really seeking here? The consequence of this, I think people need to understand. They're doing it for a reason. And we say running away from New York, we say, oh, they're alleging political witch hunt and all of that. But the actual consequence of their being permitted to reorganize with a complete clean slate, if they are successful, if the bankruptcy is not dismissed, and if they go through the process and they come out the other side reorganized, what will that mean for all of what they pretty openly say they're trying to run away from in New York?
Well, I'll give a qualified answer, because I'm not exactly sure the full range of powers of the New York Attorney General. But in one sense, what they will gain is, if I had to kind of pick a single word, would be continuity. Because what they're trying to do is almost exactly what the New York Attorney General is asking. They're trying to dissolve themselves in New York and reincorporate in Texas. Mm-hmm. And I think what they're trying to do is to do that with some continuity of organization. Because if you dissolved in New York, you'd have to redistribute the assets and transfer. It would be, I think the technical word is a hassle to try and kind of get all that stuff into somebody new. In bankruptcy, the bankruptcy code would permit that transfer basically with the stroke of a pen, or the imprimatur of electrons on a PDF. I mean, however that goes these days. And so what they're trying to do is say, listen, we're going to be the exact same. We're going to have the same liabilities. What I would say is, we're going to have the same liabilities. We're going to have the same structure. We're financially sound, so we're not going to affect any. And you can file a plan without affecting certain creditors. You just say, listen, you're not affected by the bankruptcy. And that's what Texaco did to go all the way back. They said, all of our trade creditors, you're not, everybody else, you're not going to be affected by this bankruptcy. We're only going to deal with the things that cause us troubles. And so the question in my mind, though, is what the residual remedies of the New York Attorney General are if you dissolve. I mean, presumably they could just say, okay, we've dissolved, you no longer have jurisdiction over us, bye-bye. And what I don't know is what, under New York law, the residual remedies of the Attorney General would do if someone flees their jurisdiction because of allegations of fraud. It would not surprise me if they had damage claims, for the Attorney General's investigation, or some penalty or something like that. It can't be huge, though, I would imagine, but I don't know. So in one sense, what they're asking for is exactly, it's not inconsistent with what the New York Attorney General is. I mean, the New York Attorney General.
In other words,
Yeah.
both the New York Attorney General and the NRA itself, through the bankruptcy mechanism, are seeking to dissolve.
Yeah, well, they're seeking to get rid of a New York tie.
Yeah.
What the New York Attorney General can't do is tell them where they can, that they can't incorporate someplace else. I mean, the New York Attorney General's authority ends at the state line. And what they're using in bankruptcy is the ability to kind of cross those state lines through a bankruptcy order that just says, there's now a Texas version of the NRA, and it will assume all the assets and liabilities of the New York version.
Well, that's I guess the question that I've had, that last part, assuming the liabilities, right? Because in a lot of cases, in the majority of cases that you told us about earlier involving consumers, when you come out of bankruptcy, you have resolved those pre-bankruptcy
discharge. You've gotten rid of them.
Discharge. Yeah. Here, well, I mean, can they do that? Can
sure.
The NRA go through this and simply say to New York, sorry, we have reorganized, and any exposure that we might have had when we were in New York, penalties, dissolution, restitution, damages, whatever potential for recovery the New York State Attorney General may have had, NRA now can say, see ya. We're
well, they can't really say see ya. I mean, especially with a nonprofit. Bankruptcy is incredibly flexible in terms of how it handles post bankruptcy claims. It can, as I said, with Texaco, can just simply say the bankruptcy is not going to affect them. Mm-hmm. It can also say, that is discharged. That is to say, you no longer have to pay anything. More common, especially in Chapter 11, is to say, well, here's the payment plan we are going to use. And so they say, in New York State, you think we owe you $5 million, we'll pay it $1 million a year over 5 years. Now that has to be in a plan, a document that they will produce that the court has to approve, and there are 17 different preconditions for approval of a plan. One of the things that would be very interesting here that I have to kind of talk about a for-profit business versus a nonprofit business. In for-profit businesses, there are two concepts, because I'm going to assume the New York Attorney General is going to say no or hell no to any treatment that the NRA will give it. You can confirm a plan over the dissent of a creditor or a class of claims, but in for-profit businesses, there are two rules that limit that. One is, well, first you have to comply with all the other requirements that everyone else has to comply with in terms of showing that this is a viable reorganization, that people are going to get more than they would get in a reorganization. But two additional requirements are called the absolute priority rule and then no unfair discrimination. In a for-profit business, the absolute priority rule says the equity owners can't take anything. They can't keep their interest unless you pay all senior creditors in full, or unless they consent, and they consents by a class. So in most small companies, there's usually consent to let the owners continue. But if there's no consent, like for example, if they're crosswise with their bank, Chapter 11 is not a good move because they can lose their equity ownership because they can't confirm a plan that doesn't pay their creditors in full without their consent.
So
Unfair
that's in a private company. So
right. That's in a private company. How that applies in a nonprofit where there are no owners, generally the notion is that you got to pay senior claims before you pay junior claims. I'm not exactly sure how that would play out in the NRA as a nonprofit. The other and probably more applicable provision is something called no unfair discrimination. And because of the word unfair, it means that you can have some discrimination among creditors of the same rank, right? Unsecured creditors are everybody. Like, for example, in mass tort cases, at common law, a tort claimant has the same priority as a trade creditor as someone who is owed money on a contract claim. They're all unsecured creditors. But in most mass tort cases, you pay them differently. You may pay the tort creditors over a longer period of time because you don't have that much money now. And you may pay your trade creditors up front because you want them to kind of stay with you. Mm-hmm. As long as you give them approximately the same return, it's not unfair discrimination. I'm not exactly sure how the NRA will deal with that. They will probably what's called separately classify the NRA into a different class from its other creditors. And then seek to confirm over their dissent. But to do that, they would have to show that the classification is not unfair. That's tough. And they would have to show that, and I'm not exactly sure how, but they would have to show that all senior claims are being respected before any junior claim holders are taken care of.
I think to a lay person, there may be a sense that bankruptcy at least has the potential for a person who has acted badly or maybe just irresponsibly to avoid the consequences of that bad action or that
absolutely
behavior. And that must be true in some number of cases. I mean, you speak of helping people get back on their feet, and that's kind of the noble side of bankruptcy. And I think that's also very important to bear in mind about what we're talking about here. But I think there is that sense that bankruptcy certainly can be used to avoid the consequences for bad or irresponsible behavior in the past. Yeah, well, go ahead. I
was just going to say, in 9 years on the bench, I saw more than a few scoundrels and scallywags who were trying to take advantage of the system. On the consumer side, by far, I mean, more than 98% of people were just, in bad situations. People who bought a house they couldn't afford because the school district was better for their kids. Mm-hmm. People trying to live the American dream and kind of their reach exceeds their grasp. But for individuals, there's a whole slew, 19 reasons why you could be denied a discharge on a particular debt: fraud, a defalcation, intentional tort injury, non-payment of a condo homeowner due. Don't ask me how that got in there, but that's there. There's the statutes are political. There are some political things.
Somebody lobbied for that and got it.
Yeah, somebody lobbied for that. But the basic core kind of bad acts are there. But they only apply to individuals. Corporations can discharge fraud claims. They can discharge what would otherwise be non-dischargeable for humans. The reason for that is to try and get something through the system quickly and to say, listen, that can be taken care of by a vote if people want to discharge that going through. So yes, there are lots of shady corporations, for example, who will prey on the elderly, who will prey on the uninformed, who could file bankruptcy and not be liable for the fraud claims on damages. But that gets us back to kind of the point where, a trustee or an examiner is always a possibility in those cases. And the idea is if you get an independent person to take control, that they will do right, or they will at least do what they can. I mean, in one sense, the vehicle, the corporation, is not the bad actor. It's the people who motivated it. It's the people who drove it.
Yeah, that is it. I mean, that is the difference between a corporation and a person. I mean, you can't separate the head of the person from the whole of the person,
Right.
but you can separate, let's say, a corrupt management team of a company or an organization, in this case,
Right.
From its body, and maybe that's where you were thinking of going in when you said earlier that the NRA may have a good malpractice claim, because that could very well be the outcome here. I mean, Wayne LaPierre and his cohorts at the head of this organization could find themselves on the street by the time
find themselves, or more importantly, find themselves on the wrong end of a restitution lawsuit. And again, they were at that risk anyway, right? I mean, people who do bad things are always at risk. The question is, do you increase that risk? And I would say filing a proceeding under which the statute provides, in the case of the actions you've been accused of, to appoint an independent person to look at them, or to run the company, increases your potential for liability. And also, if it gets dismissed on the basis that I mean, for example, if the court, Judge Hale says, you've said you don't need bankruptcy, and this is a kind of a bad faith filing, be gone. Someone's going to pay those lawyers, and that's whoever authorized that cost. It's like authorizing somebody to do something that we know that they're not permitted to do. Someone's going to bear that cost.
Fascinating. Well, there's gonna be a lot, and this was just filed in January, so we're early on in the process down in Texas.
Yeah, I believe the motion to dismiss is supposed to be heard March 29th.
So we've got some time, but we'll keep a close eye on this. And thank you so much, Bruce, Professor Bruce Markell, retired judge, former Judge Markell. Thank you so much for walking us through this. I always had I don't know that bankruptcy was my strong suit in law school. So I appreciate that.
That's okay. I never took it in law school.
Well, there you go. And I'm a tort lawyer, and torts was my worst class in law school. So
I worked my way through undergraduate being a paralegal in a personal injury firm.
Did you really? I'm fantastic.
Yeah.
Are you from California originally? I know you went to Davis for
that's a longer answer. I mean, I was actually born in the Midwest. I moved out to California in middle school, junior high. So high school, college, law school, first 10 years of practice in California.
Well, that qualifies. Okay.
Yeah, no, if it helps me, I'll claim almost anywhere in the U.S. as kind of my origins. So.
Well, thank you so much again, Bruce. I really appreciate it. It was such a pleasure meeting you and being able to talk with you today. Thanks so much.
Thank you. Thank you.